Hello, everyone. Thank you for joining us for this installment of the California Employment News, an informative video and podcast resource offered by the Labor and Employment Group here at Weintraub Tobin. My name is Ryan Abernethy, and I'm a shareholder in the firm's Labor and Employment Group with over 15 years of experience representing California businesses. And I'm joined today by John Slavik, an associate attorney from our group, who is a seasoned employment litigator. And I believe this is his first episode on our channel. So we're happy to have him here on our team. So today we'll be diving into Senate Bill 294, also known as the Workplace Know Your Rights Act. And that's a new piece of California legislation that touches on a hot topic of immigration in the workplace. So John, let's get started with the substance of this bill. So what's it all about?
Senate Bill 294, signed into law this year and effective January 1st, 2026, is designed to enhance workplace protections, particularly in response to concerns about immigration enforcement action by the federal government. The bill imposes two new key requirements on California employers. First, it mandates a new workplace notice that informs employees about their rights under California law. This includes protections against unfair immigration-related practices and employees' constitutional rights when interacting with law enforcement at work. Second, if an employee is arrested or detained at the workplace, the employer must, upon the employee's request, notify a designated emergency contact. Ryan, can you tell us more about the new notice requirement?
Sure. Yeah. So there's a standalone written notice that must describe the worker's rights regarding four particular topic areas. The first is the employee's right to worker compensation benefits. The second is their right to notice of inspection by immigration agencies. The third is protections against unfair immigration related practices against a person exercising protected rights. And fourth is their right to organize a union or to engage in what's called concerted activity in the workplace. So the bill requires the labor commissioner to provide a template notice before January 1st of 2026 in 9 different languages and to update this notice annually. The law also requires the labor commissioner to produce a video for employees advising them of these rights that employers may, if they choose, show to their employees in addition to providing the written notice. So then employers will have until February 1st of next year to distribute the notice to employees in whatever manner the employer usually distributes such information, such as personal delivery or email or text message. And the notice must also be made available to all employees upon hire. The employers are required to keep the records of compliance with the notice for up to 3 years. So John, why don't you tell us more about SB 294's, what it has to say about an employee's designated emergency contact?
My pleasure. SB 294 gives employees the option to have an emergency contact be notified if the employee is arrested or detained at the worksite. But if the employee's arrest or detention does not occur at the worksite, then the employer should only notify the emergency contact if the employer has actual knowledge of the arrest and if the arrest occurs during the employee's work hours or while the employee is performing his or her duties. When SB 294 takes effect next year, an employer must provide employees with the opportunity to name an emergency contact no later than March 30th, 2026. Employees must also be permitted to update their emergency contact throughout their employment. Unfortunately, with these new obligations comes new potential punishments for noncompliance. An employer who violates SB 294's new requirements can receive a penalty from the Labor Commissioner of $500 per employee for each violation. And if the violation is a failure to notify an employee's emergency contact of the employee's detention, then the penalty is $500 per employee for each day that the violation occurs, up to a maximum of $10,000 per employee.
Thank you, John. So more for employers to be worried about here. And, just so you're all aware, you can always reach out to one of our attorneys here at Weintraub if you have any specific questions about this new law. And that does it for today. And thank you all for joining us. You can continue to find California employment news on our blog at www.thelelawblog.com and wherever you listen to your favorite podcasts. So we'll see you next time. Thank you for joining us.